Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's good to have you here. It's Friday. I've only put out one episode this week. My kids went back to school yesterday. It was just a crazy week. You know how it is getting ready for all that. But now that they're settled, I'll be doing a lot more regular episodes like I normally do. I just decided this summer to take a little time off every now and then just to spend some days with them and enjoy them being out of school. But it's going to be a busy, busy fall. We're back full force. Before we get started, if you're watching on YouTube, you know the drill. Don't forget to hit subscribe if you haven't already. Like the video, share it with your friends, and you can ring my bell if you want notifications of when I post new content. Click that little bell icon. Music fact of the day. What hit song by Heart was actually meant for Stevie Nicks, but she passed? These Dreams. Great song. So let's jump in. There's a lot of speculation right now that Alec Baldwin may sue the sheriff's office as well as Prosecutor Morrissey. His legal team told the prosecutor and the sheriff's office to hold on to any emails, text messages, hard drives, documents, records, and materials related to the investigation and prosecutions connected with Ms. Hutchins' death. They're requesting all communications between the sheriff, the district attorney, and the prosecutor to be preserved, or any communications and information referencing or related to Baldwin be preserved. Kind of a telltale sign. We will see. Well, let's jump into Judge Marlo Summers' ruling. This was filed on July 31st. The filing says that during pretrial litigation, defendant Baldwin filed 4 motions concerning allegations the state failed to comply with the court's scheduling order and other discovery requirements established by law. On June 24th, there was an expedited motion for relief from state's Brady and state law disclosure violations related to the firearm. This motion concerned late disclosures made by the state relating to expert witness reports and statements by expert witnesses which bore on the functionality of the firearm that discharged the bullet that killed Ms. Hutchins. Although the court found the state had culpability making late disclosures, the court denied the motion on the grounds the defendant had not established prejudice as defined in relevant case law. Also, on June 24th, the defendant filed an expedited motion for relief for the state's Brady and state law disclosure violations related to non-firearm discovery, including thousands of files, 150,000 pages of documents, and dozens of gigabytes worth of data. The court found the state had culpability of late disclosures. It was denied on grounds discussed in the previous motion. The court acknowledges the state's representation. They conducted a complete audit of its discovery disclosure files as soon as it was aware that potential problems existed and had cured any discovery disclosure issues. On June 26th, Baldwin filed a motion to compel disclosure and impose sanctions. This was regarding state's expert witnesses' statements and discovery issues relating to witness statements remained ongoing in the days leading up to the trial. The filing claimed Special Prosecutor Johnson disclosed over 1,100 pages of documents that Morrissey previously refused to provide. July 5th, Baldwin's reply in further support of motion to compel and impose sanctions was denied on July 8th after the parties agreed to a meet and confer to resolve the motion. June 27th, there was a motion to exclude the opinions of Lucian and Michael Hagg. They are firearms experts, I believe, by the way. The court denied this, saying the discovery was not late and the arguments were duplicates of previous arguments. Looks like here to me, the state really got a lot of breaks by the judge before this trial started, but it caught up with him in the end clearly. She goes on to say the defense filings discussed above demonstrate the state continually made late disclosures to the defendant during pretrial litigation and even in the days immediately preceding the jury trial, which began on June 9th. Opening statements were the next day on July 10th. On July 11th, during cross exam, crime scene technician Marissa Popple was asked by the defense about ammunition submitted by a Good Samaritan near the conclusion of Hannah Gutierrez Reed's trial, the armorer. They quote the testimony where Popple acknowledges the ammunition was turned in, and further questioning revealed these rounds were related to the Rust investigation. The judge says the ammunition was inventoried and a supplemental report was made and given a non-Rust inventory case number. She quotes Popple as verifying that on the stand. She goes on to say that Baldwin wasn't given the opportunity to inspect the new evidence when they inspected ammunition inventoried under the Rust case number. On redirect, the Good Samaritan was identified as Troy Teskey, a good friend of Hannah Gutierrez Reed's father, Thel Reed. The filing goes on to quote the prosecutor and Marissa Popple, where the prosecutor asked the witness, "You can bring it in here and show it to the jury, and they can see it doesn't match the live ammunition from the set, and it's obvious when you look at it that it's not." Marissa Popple answered yes. The defendant alerted the court that they would file a motion regarding the state's failure to disclose the supplemental report and make Teskey ammunition available for review by the defendant. They go into that hearing from July 12th about the state's failure to disclose the supplemental report and also the lack of opportunity to inspect the ammunition. The filing goes on to recap the prosecutor's argument that all the ammunition from the 1883 set came from the same place. Some of those rounds were sent to Set and some were left at Mr. Teskey's place. The prosecution sent a photo of the suspected live rounds to Seth Kinney. He owns that PDQ warehouse, and also to Corporal Hancock. And the prosecutor said at the hearing during trial that she would enlarge the photos to show they aren't the same. And then she decided, along with Corporal Hancock, they had no evidentiary value. They go through the court inspecting the ammunition. Remember, the judge came off the bench, put on some rubber gloves, got her hands dirty right up in there. I've never seen that before. The defense sought to establish a progressive trail to demonstrate the relevancy of the Teskey ammunition. Number one, 45 caliber ammunition possessed by Troy Teskey. Number two, some of that ammunition was then possessed by Seth Kinney and Thel Reed for use at the 1883 Cowboy Training Camp. Number three, Seth Kinney then took leftovers of that live ammunition to PDQ warehouse in Albuquerque. Number four, Seth gave reported 45 Colt dummy rounds with brass casings and nickel or silver in color primers to Sarah Zachary on October 12th, 2021. Remember, Sarah Zachary was the prop master. Hannah was helping her with props on the days there wasn't an armorer heavy day. And in return, Sarah Zachary was helping Hannah with armorer duties in spite of the fact she had never fired a gun. Number five, Sarah introduced those rounds to the set of Rust before the October 21st incident. The judge goes on to summarize Corporal Hancock on the stand, testifying that crime scene technician Popple's testimony in front of the jury was false. And it also notes Prosecutor Morrissey elicited this testimony through leading questions. Corporal Hancock also testified once she was aware of Popple's collection of the Teskey ammo, Special Prosecutor Morrissey and Corporal Hancock's supervisors at that time decided to inventory and give the ammunition a non-Rust case number. They mentioned the body cam video of Lieutenant Brian Bandel with crime scene technician Popple and another female present when Mr. Teskey met with them at the sheriff's office on March 6, 2024. Prosecutor Morrissey takes the stand and says the Teskey ammunition never left Arizona and it was not similar to the live rounds found on set, saying she had no reason to believe they were relevant. When confronted by the defense that she never let them view that ammunition, she said she had not seen it and didn't realize it was under a different case number because she's not law enforcement and doesn't work at the sheriff's office. but said that is correct. It was given another case number. The filing notes that testimony conflicts with Corporal Hancock's, who said that Santa Fe Sheriff's Office agents and Prosecutor Morrissey decided to file the ammunition separate from the rust evidence, and Prosecutor Morrissey also admitted that Marissa Popple gave false testimony in front of the jury July 11th when she said the rounds given by Teskey didn't resemble the rust ammunition. She said she didn't realize that there were rounds that looked like the ones found on the rust set. The filing goes on to say the motion was granted and the non-disclosure impacted the fundamental fairness of the proceedings. The Brady guidelines were laid out in the filing, with the judge giving examples of each one related to Baldwin's dismissal. Number one of the Brady guidelines, prosecutors suppress evidence. There was testimony from multiple witnesses that established the state did not provide the Teskey ammunition, the related supplemental report, and the body cam footage. The prosecutor and the Santa Fe Sheriff's Office agents made the deliberate, intentional decision to put the ammo under a non-rust case number. The court concludes the state suppressed the evidence. The suppressed evidence is favorable to the accused. The judge said the suppressed evidence was used as impeachment evidence during the cross of crime scene tech Popple on July 11th. Regarding Popple's lack of knowledge, due to a lack of further testing about whether the sheriff's office possessed ammunition that matched the ammunition that killed Ms. Hutchins, in addition, the evidence is potentially exculpatory. This likely affects the jury's information concerning how the ammunition arrived on the set and their calculus of proximate cause and negligence by a third person or persons. Third, the suppressed evidence is material. The judge said the disclosure of evidence during the trial has impeded the effective use of evidence in such a way that impacts the fundamental fairness of the proceedings, and because of the late disclosure, the defense was not in a position to forensically analyze or ask the state to analyze that Teskey ammunition as the state had done with other ammunition that was relevant to the rust investigation. If the defense had access to the ammunition, the judge agrees the defense could have altered their approach to preparation before and during the trial. The court finds the suppressed evidence is material. She says the defense established a Brady violation, which amounts to prosecutor misconduct. The state is highly culpable and required to timely produce discovery under numerous state and federal case law. The prosecutor and the Santa Fe Sheriff's Office agents deliberately withheld this evidence when deciding to place the ammunition under a different investigation case number. Special Prosecutor Morrissey's belief that the ammunition had different physical characteristics than the live rust ammunition is no excuse for the state's suppression of evidence, and the court finds the state's level of culpability rises to the level of willful and deliberate misconduct. The court finds the defendant established he was prejudiced by the late disclosure and discovery order violations. The evidence is material, and disclosure is so late it undermined the defendant's preparation for trial. The evidence is material in that the Teskey supplied ammunition relates to the two most critical items in the case from an evidentiary perspective. Number one, the firearm, and number two, the live ammunition from the set. The defense could have used the evidence as impeachment material against multiple witnesses and sheriff's office investigation generally. The dismissal with prejudice was justified due to the state's late disclosure. The dismissal with prejudice is appropriate for the following reasons. First, the state repeatedly failed to fulfill its discovery obligations during pretrial litigation. Second, the state's suppression of the Teskey supplied ammunition and related evidence constitutes willful and deliberate misconduct. Third, Special Prosecutor Morrissey elicited false testimony from crime scene tech Popple on July 11th in the presence of the jury. Fourth, a mistrial would not be based on manifest necessity and jeopardy and had attached well before information concerning the non-disclosures came to light. I looked this up. What is manifest necessity? It's a circumstance that is so overwhelming and unforeseeable that it makes it impossible to conduct the trial or reach a fair result. A mistrial may be necessary in these circumstances, and the defendant may be retried without violating the prohibition on double jeopardy. But the judge says it's not proper here because it would be based solely on the state's discovery violations, and a mistrial is improper. Fifth, lesser sanctions such as adverse interference, jury instruction, monetary sanctions, a continuance, or a reprimand would not cure the fundamental unfairness. Dismissal with prejudice is the appropriate remedy. She goes on to say that the state's discovery violations injected a needless, incurable delay into the jury trial. Further, the state elicited false testimony from a state witness. Dismissal with prejudice pursuant to the court's inherent power is additionally warranted to ensure the integrity of the judicial system and the efficient administration of justice. Therefore, the court grants defendant Alec Baldwin's dismissal and sanctions. Moving on to Special Prosecutor Morrissey's response to Hannah Gutierrez Reed's request for a new trial. We know this is based on what happened to Alec Baldwin's trial. Let's go through the highlights. It was a very lengthy filing. It was, I believe, 44 pages. I picked out the best parts. It says that Hannah complains of 4 issues she alleges supports her motion for a new trial. First, the defendant argues that undersigned meaning Ms. Morrissey, counsel lied under oath during a motions hearing in Baldwin's trial and failed to disclose ammunition obtained by her father's close friend, Troy Teskey, in March 2024. Second, the defense raises concerns of an audio recorded interview of Seth Kinney that was not disclosed until after her trial concluded. Third, the defendant asserts she should be granted a new trial because the supplemental report produced by Lucian, I believe it's Hag or Hogg, Haag, on August 31st, 2023 was not given to her counsel prior to trial. This witness was a firearms expert, by the way. And fourth, the defense asserts she should be granted a new trial because there are unremarkable emails between the state's experts that were not disclosed to the defendant during trial. This is in all caps, by the way. Baldwin trial and defendant Gutierrez allegations of misconduct. Undersigned counsel did not lie under oath. Counsel testified she was aware Teskey provided ammunition to the sheriff's office at the end of her trial and was not aware of the doc report outlining the facts the ammunition had been provided to the sheriff's office, did not contain the same case number, or would not be linked to the same case number as the rest of the evidence related to the Rust investigation. This was a true statement, and counsel qualified her statement during cross-exam by explaining she misunderstood the doc report would have a different case number assigned because she is not a law enforcement officer and doesn't work at the sheriff's office. Corporal Hancock understood the new document would have a different case number because it was a separate document report. Counsel did not understand doc reports have different case numbers due to her lack of familiarity with the manner in which case numbers are assigned at the sheriff's department. Counsel and Corporal Hancock testified truthfully. Counsel testified truthfully when asked why Miss Johnson, that's the special prosecutor, withdrew from the case during the motion hearing prior to the lunch break on July 12th without hearing any testimony or argument related to Baldwin's motion to dismiss. The court went off the record and told the state and the defense she was intending to dismiss the case. That makes sense. If you remember, we were getting reports from inside the courtroom by Lauren Matthias from Hidden True Crime and others that the defense looked happy. Baldwin was seen laughing. So now we know. The judge let them know she was probably going to dismiss this case. Based on the court's off record statement, it was apparent the court was intending to dismiss the case, so the state had two choices. One, dismiss the case on its own, or two, have a full hearing, develop a record, and let the court dismiss the case. Special Prosecutor Miss Johnson wanted the state to dismiss the case and stated she wanted the case dismissed out of concerns for self-preservation. I disagreed that self-preservation was an inappropriate reason to dismiss a homicide case, disagreed a dismissal was warranted under the circumstances, and proceeded to a full hearing. Ms. Johnson didn't want a public hearing out of concerns for self-preservation, and I testified truthfully in this regard. Just a note here, Special Prosecutor Johnson talked to the media and said the reason that she withdrew from the case was because she found out along with us that this happened. This was not something she was forewarned about, and as soon as she learned, she hopped off. Prosecutor Morrissey goes on to say, I've not had a win at all cost attitude in the Rust cases. It's been the opposite, and Hannah's attorney, Mr. Bowles, knows it. I attempted to resolve Hannah's case with an agreement that would have prevented her from being incarcerated and becoming a convicted felon. Presumably, upon the advice of her trial counsel, she declined the plea offer, as is her right. I then went so far as to file a sealed motion asking the court to counsel her about the plea offer on the record to ensure her refusal to accept the offer was knowing, intelligent, and voluntary. The court denied to put the plea offer on record and ensure Hannah understood the consequences of her decision. I also offered a plea to a misdemeanor to Alec Baldwin, but rescinded the plea offer when further information surfaced regarding Mr. Baldwin's conduct with material witnesses in the case. This is hardly a win at all cost attitude. I testified truthfully that Mr. Bowles, that's Hannah's attorney, did not want the Teskey rounds. Mr. Teskey made a statement when providing the rounds to the sheriff's office. He was asked by Hannah's defense to testify on her behalf and bring the ammunition in his possession to her trial. He did as he was asked, but Mr. Bowles decided not to call him as a witness and not use the ammunition. Mr. Teskey specifically stated to law enforcement that Hannah's attorneys didn't want the evidence he brought from Arizona. It's stunning that Mr. Bowles now claims his client was prejudiced by the state's failure to disclose ammunition that was not in the state's possession, but in the possession of a defense witness and was available to defense counsel. Mr. Bowles provided 4 photos to me which depicted 4 rounds that had brass primers. Only one had Starline brass casings, and all had projectiles dissimilar to the ones on the Rust set. Mr. Bowles is the person who provided me with information that caused me to abandon any efforts to obtain or test the rounds. The only information I had was the information provided by Mr. Bowles and Mr. Teskey, and all the information was that the rounds in Teskey's possession were dissimilar to the ones on the set of Rust. She brings up the text that Mr. Teskey had with Seth Kinney, the ammo supplier. She included a photo of all the different types of .45 caliber ammunition that Mr. Teskey could find that he was storing for Hannah's dad, Thel Reed, after that 1883 cowboy camp before they started filming that great series, by the way. Highly recommend you watch it. All dissimilar to those on the Rust set. 2 years later, in November 2023, Mr. Teskey's pretrial interview was conducted, and he was being called as a defense witness at Hannah's trial. I asked about the ammunition and considered taking steps to obtain it, but had difficulty determining if it was material evidence. On January 8th, 2024, Mr. Bowles provided photos of the ammunition and asked if I would send the rounds to the FBI for testing. The photos were the exact rounds sent to Seth Kinney, confirming they're dissimilar to the live rounds found on set. To be clear, the ammunition in Mr. Teskey's possession were owned by Hannah's father, Thel Reed, and never left the state of Arizona until Mr. Teskey brought them to New Mexico at Mr. Bowles' request during Hannah's trial. They were not in the state's possession until March 6, 2024. On November 3rd, 2021, Seth Kinney asked Mr. Teskey if he located any rounds with silver primers. Mr. Teskey responded, no. The first time I became aware Mr. Teskey was in possession of rounds that looked similar to the ones on the Rust set was the morning of July 12th, 2024, because I was under the impression the rounds received by the sheriff in March were the same rounds from the photos provided by Mr. Teskey in November of 2021 and January 2024. It is highly suspect that Mr. Teskey provided rounds in November 2021 and January 2024 that are completely dissimilar to the live rounds on the Rust set. Confirmed in writing November 2021 that he was unable to locate rounds with silver primers. Then on March 6, 2024, he dropped off rounds similar to those from Rust. That ammunition was never in the possession of Seth Kinney or any other witness on the state or defense's witness list in the Baldwin case, other than possibly Hannah herself, but the court was unwilling to compel her testimony. I'm still struggling to understand how ammunition that was never in the possession of, seen by, or known to any witness being called was turned over 2.5 years after the death of Ms. Hutchins, and how that created a discovery violation that justified a dismissal with prejudice of Baldwin's case. The rounds turned over by Mr. Teskey all belonged to Thel Reed, and 3 appeared similar to the live rounds found on set. There's no evidence any of these rounds were in the possession of Mr. Kinney or anyone other than Thel Reed, Mr. Teskey, and possibly Hannah. Hannah said in her second interview with Corporal Hancock in November 2021, she sourced her dummy rounds from her father. The evidence doesn't support a sabotage theory. It supports what the state has asserted all along. Hannah brought the live rounds from the set of Rust after obtaining them from her father. If we assume the live rounds found on set were planted by sabotage, even though they appear identical to Thel's rounds produced by Troy Teskey, it was still Hannah's job to inspect the rounds before putting them in the firearm. She failed at this simple task, and it resulted in someone's death. For this failure, she was tried and convicted. As discussed at Baldwin's trial, she photographed herself in possession of live rounds on or about November 30th, 2021. She sent the photos to her attorney, and they were later discussed in texts that included Thel Reed, thus breaking any privilege that may have existed despite Hannah's full waiver of privilege with regard to her cell phone extraction. These photos make the Teskey rounds even more inculpatory and not at all exculpatory. She said she intended to use the rounds if Hannah had testified. She said all the FBI can determine is whether the powder used in the rounds are the same as the ones used on set, but that powder is used by countless manufacturers who make millions of cartridges each year. It is legally questionable whether Mr. Teskey had standing to consent to the seizure of Mr. Reed's property without Mr. Reed's consent, and I was never provided any consent to obtain or test the rounds by Mr. Reed. She says in Hannah's motion for a new trial, it asks, how can it be any different with Hannah's case with this proven litany of serious discovery abuse? The answer is twofold. First, the question assumes the court properly dismissed the case against Baldwin. She is doubling down, y'all. Crazy. I contend the court misunderstood the testimony on July 12th and improperly dismissed the case against Mr. Baldwin. For the court to properly dismiss against Baldwin, the court needed to find the evidence to be favorable to the accused, either because it's exculpatory or because it's impeaching. That evidence must have been suppressed by the state, either willfully or inadvertently, and prejudice must have ensued. Mr. Baldwin was charged with violating all rules to ensure firearm safety by actors on movie sets by pointing his gun at two people during a rehearsal, cocking his gun when rehearsal did not call for that action, and pulling the trigger when rehearsal didn't call for that action. The case was dismissed due to the state not disclosing the Teskey ammunition to Baldwin's defense, and there was evidence the ammunition was never possessed by, seen by, or known to any witness being called by the state or defense. The evidence is not exculpatory as it has nothing to do with the basis for the charge against Baldwin, and it's not impeaching Seth Kenney or any other witnesses. And no other witnesses never possessed it or had knowledge of it. The state concedes it was suppressed from the defense because law enforcement was unable to develop any evidence that established the relevancy to Ms. Hutchins' death due to Mr. Teskey's unwillingness to provide an interview to law enforcement. Baldwin suffered no prejudice due to the lack of connection of the ammunition to Seth Kenney, and his team was well aware of the ammunition prior to trial because they suddenly canceled an evidence viewing in mid-June 2024 and cross-examined Popple at great length regarding the Teskey ammunition. If the court were to decide dismissal for Baldwin was proper, there's one huge difference, and she puts huge in all caps. In Hannah's case, the state was not in possession of the Teskey ammunition prior to trial, although arguably Mr. Bowles was. Mr. Bowles is comparing apples to oranges and trying to make a square peg fit in a round hole. She said she was unaware Seth Kenney met with investigators at the DA's office and provided a recorded statement. That happened October 27th, 2021. Prosecutor said she learned this after he met with Baldwin's attorney for a pretrial interview. She reached out to investigators and found a recorded statement did exist. She asked for a copy and then she shared it with Hannah's attorney. She said Mr. Kenney's statement was consistent with the text between himself, Sarah Zachary, and Hannah, and all those messages were given to the defense. She then goes on to say Mr. Bowles points to 20 statements that he says warrants a new trial. For the sake of time, I'm not going to go through those, but one did say that Mr. Bowles had the opportunity to interview Seth Kenney and Corporal Hancock and then ask about any inconsistencies, but instead he sent co-counsel and or his investigator. She concludes by saying there is nothing about undersigned counsel's testimony with regard to Ms. Johnson's departure from the prosecution team that is at all relevant to Hannah's motion for a new trial, nor is there anything relevant to undersigned counsel's statements with regards to Mr. Taub's departure from the prosecution team. One thing that was included in this filing, apparently Mr. Taub was relieved of his duties in this case. Apparently it was due to the quality of his work. He complained he was not given much to do at all. Likewise, there is nothing relevant about the circumstances related to the doc report and the case number assigned to the report and the Teskey round that is relevant to Hannah's motion for a new trial, as the evidence at issue was not in the possession of the state until the end of her trial and not prior to the trial. Man, she is just not backing down, saying essentially the judge made the wrong call. Kind of one of those things where it was so obvious to me, and I'm not even an attorney, that there were a lot of violations. And thank goodness we have the Constitution to protect our rights, because if that were you in that defendant chair and this happened, you would want the same thing. At the end of the day, horrible tragedy that was preventable in so many different ways. And I think the best thing moving forward is maybe the movie industry understands that don't cut corners and don't entertain us at the expense of somebody's life. Let's pop some CGI at the end of these guns. I mean, come on, we got the technology. That's it for this. We're going to keep an eye and see if anything else pops up. Next week, we're going to be catching up on some cases that we've been following. Corey Richards, Chad Daybell. We got some things to update there. And then we're going to be hopefully going back into the Adelson documents. I'm waiting on the rest of those. Can't wait to get the rest of those out. Very interesting stuff in there from what I'm told. I haven't seen it yet. We're going to bring that to you as soon as I get it. Hope you guys have an amazing weekend. We will see you soon.